Good morning. This short video will deal with the principles of what is a search. If you remember what we said, if we're going to do a Fourth Amendment analysis, there's some requirements, there's some things that you must go through, some questions that you must answer. First question is, does the person have standing? The next question is, their government action? If you find that they're standing, then there's government action. Then you have to make a determination if there's a search or a seizure. There are some very, very particular, very specific cases that deal with whether there's a search. The first case that we want to take a look at is United States versus Katz. Katz basically defined search or determined what a search was in reference to electronic surveillance. It Katz basically says a person must exhibit, in 1967 case, a person must exhibit a subjective expectation of privacy, and that expectation is one that society is prepared to recognize as reasonable. If you can remember the facts in Katz, Katz was inside of a telephone booth making a telephone call. The government suspected that he was engaged in illegal gambling activity, and they placed a recording device on top of the telephone booth in order to hear his conversation. And that's all the government said that we wanted to hear was his conversation in regards to illegal activity. Thus, Katz says, hold it. What you've done, you've violated my Fourth Amendment right, you've violated my Fourth Amendment privilege, you've conducted a search. The court basically says that, look, there's no search. There's no search when there's no violation of the person's reasonable expectation of privacy. And here, there was a violation of the person's reasonable expectation of privacy. The courts based it upon a two-pronged test. That two-pronged test was the person exhibit a subjective expectation of privacy. And and that subjective expectation of privacy must be one that society is ready or willing to recognize, prepared to recognize as being reasonable. A subjective expectation of privacy, and society must be willing to recognize it as being reasonable. An individual's expectation of privacy, a subjective expectation of privacy, is based on what he does, what the person does for the purpose of protecting or telling the government or telling others that, look, I want this particular activity to remain silent. I want it to remain private. A person, an individual must take affirmative steps to protect his privacy interests if he's going to manifest a subjective expectation of privacy. And that societal expectation, what society will accept it as being reasonable, is controlled by societal norms. It's controlled by the norms of society. What would society expect? A person that's engaged in this particular activity, would society expect the person to have an expectation of privacy based upon what he's done and also the place or thing that has been violated, the place of thing that has been searched or seized by the government? Now, that two-pronged test actually overturned a case of Olmstead, United States versus Olmstead. Olmstead basically said that the Fourth Amendment applied to tangible objects and not intangible objects. Here we had an intangible object. We had the communication. We had the communication of that particular person. The court said that those communications are protected by the Fourth Amendment. The person went into the booth. He went into the booth, he paid the toll. Not only did he pay the toll, he closed the door. He did not expose his conversation to the public. He did not intend for his conversation to be exposed to the public. And therefore, since he did not expose it to the public, the government had no right to that conversation and unless they had a warrant. There's no legitimate expectation of privacy in illegal activity. Also, is what Cass says. A person has no legitimate expectation of privacy in illegal activity. But it's not just illegal activity. It's how the government get to the illegal activity. How do they get to the illegal activity in Cass? They violated the Fourth Amendment in order to get to the illegal activity. The person exhibited he manifest a subjective expectation of privacy, and society is willing to accept that manifestation of privacy. And if the government violates the Fourth Amendment, once a person has established that in order to get that particular communication or to get to that particular information that they want for the purposes of prosecuting that person, then they violated the Fourth Amendment. However, again, there is no reasonable expectation of privacy, a legitimate expectation of privacy in illegal activity. But remember, it's how the government get to that particular moment that they gather the information, in reference to illegal activity. A warrant is required. A warrant is required. Remember, the warrant is the warrant is the cornerstone of the Fourth Amendment. Absent a warrant, absent a warrant is going to be presumed that a search or seizure is unreasonable unless there is a well-delineated exception to the warrant requirement. A warrant is required unless there is a well-delineated exception to the requirement. We must have a well-delineated exception. The warrant must be issued by a neutral and detached magistrate. The courts do not want those who are engaged in the competitive enterprise of ferreting out crimes determining what they can do. We want that to be determined by neutral and detached magistrates. We do not want police officers who are out on the beat, who are in the streets, who have some stake in the prosecution, who has some who has some outcome that they're expecting in their investigation. We don't want them to make a decision as to whether the search or seizure was reasonable. We want that to be determined by a judge. We want that to be determined by a judge. And it doesn't matter. It doesn't matter that they could have gotten a warrant here in Katz, or they could get a warrant. That everything they did was acceptable. If they don't have a warrant and they can't show that there's some exception to the warrant requirement, that's going to be a violation of the Fourth Amendment. The police officers, the government cannot make the determination as to whether there is or whether there's a violation of the Fourth Amendment or what's required in reference to the violation of the Fourth Amendment. That must be determined by a neutral, detached magistrate. Now, the next case, and Jones dealt with, if you look at Katz basically dealt with an electronic search, the suppression of the the instrument on top of the on top of the telephone booth. However, Katz became in 1967 when this case was decided. Katz became the Katz became the test that's used in order to make a determination as to whether there was a search. Katz became the case. And in all cases, when there was a question as to whether it was a search from 1967 until 2012 in the United States versus Jones, Katz was used. Did the person exhibit a reasonable expectation of privacy? Did he manifest a reasonable expectation of privacy, a right to privacy? Did he manifest a subjective expectation of privacy, I should say? Did he do something to suggest that I want to keep this thing private? What steps did he take? And if society is willing to accept this manifestation of privacy in this particular thing as reasonable, the test that was used in 1967, we had a new case that came out, United States versus Jones. United States versus Jones dealt with government placing a tracking device beneath the car in order to track the person for 30 days, and acquired over 2,000 pages of information. Now the question became whether placing this tracking device under the body of a Jeep and the body of a car, which the person had access to, the person was using, was that a search? The court said the text of the Fourth Amendment reflects its close connection to property. Consistent with this understanding, our Fourth Amendment jurisprudence was tied to the common law trespass at least until the latter half of the 20th century. That's Katz. The latter half of the 20th century. Katz said that if we're going to look at a search, we must look at the privacy expectation and whether society is willing to accept that expectation of privacy that the person has exhibited. But here in Jones, it says that, look, our historical approach has been trespassed. The government trespasses onto one of the areas listed in the Fourth Amendment: persons, paper, houses, or effects. If the government trespasses, then we're going to determine that there is a search. There is a search if there's one other element that is met. The Fourth Amendment was understood to embody a particular concern for government trespass upon the areas it enumerates. Katz did not repudiate that understanding, is what Jones says. It says that Katz did not repudiate the understanding, our historical approach, that there must be a governmental trespass onto property if there's going to be a search. What Katz did, Katz augmented, is what he says. Katz augmented the historical approach. That is, Katz deals only with electronic searches or electronic devices used in order to obtain information. The Katz reasonable expectation privacy test has been added to, not substituted for, the common law trespass test. We do not make trespass the exclusive test. Thus, Jones saying that trespass, there must be a governmental trespass. However, it is not the exclusive test because the governmental trespass test will not apply to every situation. Situations involving merely the transmission of electronic signals, an electronic search, an electronic signal, a technological search without trespass would remain subject to Katz analysis. And so it looked at Jones. It says, yes, that was GPS. The GPS did transmit information that is electronic. But the situation where there is a trespass in order to attach this particular electronic device, a trespass onto a person's paper, house, or effect, in order to gain that information, is going to fall within the traditional trespass requirement. We do not make trespass the exclusive test. Situations involving merely the transmission of electronic signals without a trespass. Here we had a trespass, and then the electronic signal was in, but first there was a governmental trespass, remained the subject of test. And so that the situation only involved the electronic signals, a technological question or electronic type device that sends, then it's going to remain under Katz. When the government has trespassed upon one of the areas listed in the Fourth Amendment, enumerated in the Fourth, for the purposes of gathering information, the purpose is important. The purpose is important. They enter into a trespass on one of the areas enumerated in Fourth for the purpose of gathering information. Jones says that that is a search. Jones says that that is a search. So we look to what the person has done. We look to what the government has done. Sotomayor, and I love her concurrence in this particular opinion. She says Katz's reasonable expectation of privacy test augmented, but it did not displace or diminish the common law trespass test that preceded it. Said it augmented it. It augmented it, and said Katz did not diminish. It did not delete the trespass test. And so Katz gave us something additional that we could look at in order to make a determination as to whether there was a search, indicating to me that she believed that Katz could still be used. Longer term GPS monitoring and investigations of most offenses impinges on expectation of privacy. The GPS could be used to track, and here it was tracked for 30 days, over 2,000 pages of information was gathered. She said that longer term of monitoring must offend that person's expectation of privacy and a violation of the fourth. GPS monitoring generates a precise, comprehensive record of a person's public movement that reflects a wealth of detail about her familial, political, professional, religious, and sexual associations. The government can store such records and efficiently mine them for information for years into the future. Justice Sotomayor was concerned with the evasiveness of this particular type of device in order to gain information. The government can perpetually attach it because no limits was placed. No, it was not decided how long is too long. And so the government can place it and gain wealth of information about the person, not just about criminal activity, but all those personal activities that the person has sought to keep private, to keep away from the eyes of the government. And basically, you have a test, two tests in order to make a determination as to whether there's a search. You have Katz and you have Jones. Katz applies to electronic searches when there's an electronic signal that's involved. Jones applies to when there's a physical trespass, when there's a physical trespass onto the property for the purposes of gathering information. That's the end of our discussion, our basic discussion as to whether there's a search. We'll continue this discussion when we look at more short videos dealing with the application of Katz and Jones. Thank you so very much.